Hi, my name is Evan Nielsen from Nielsen Law Group. I appreciate you joining us. We're going to talk just briefly about assets in a bankruptcy. Many times we're asked the question by someone who's considering a bankruptcy, am I going to lose all my assets? And the answer is generally no. Many of them you'll be able to retain. In general, the concept behind bankruptcy is that necessary and ordinary assets are the ones that a debtor should be able to retain. So, for example, under a state system like California's, household furnishings, clothes, food, etc., those are all what would be considered necessary and ordinary, and there is a blanket exemption for them. So any of the furnishings that are in your house would typically be exempt. Now, understand that each state in bankruptcy systems has its own exemption list. So Arizona, as a contrast to that, for furnishings has a specific dollar amount, $4,000 per spouse in this particular case. So as long as the value of the assets are less than the exemption level, then you'll be able to retain those particular assets. Your house is another area that you'll want to understand how it works. If you have a personal residence that has equity in it, then how much of it do you get to keep? And usually the answer is you'll be able to keep the majority or all. If you're in California, the exemption ranges between $50,000 and $150,000, depending on the living arrangements and the age of the individuals that are filing. Arizona, by contrast, just has a blanket $150,000 homestead exemption that would protect that much equity in your primary residence. So if you have more equity than that, then there may be some issues to address with the bankruptcy trustee. But generally, in a bankruptcy context, you'll be able to keep the equity in your house. There are other assets that would also generally be impacted in bankruptcy. If you have a business and you need tools or equipment that you would use, those are referred to as tools of the trade. And both California and Arizona, for example, have exemption amounts for tools of the trade. Automobiles are another area to consider. California allows $2,250 to protect equity in a vehicle. Arizona protects $5,000 per spouse. And so if you have equity in your vehicle, then you would apply the exemption to it. And so long as the equity value of the vehicle is less than the exemption, then you would retain it. Life insurance policies, retirement accounts, IRAs, 401ks, and even cash value in a life insurance policy, those are all protected under federal law, and every state has adopted some form of protection for them so that they are also exempt. And there are other details that are state dependent, and you probably surmise that each state has its own system of exemptions that apply in a bankruptcy context. But most of the time, those ordinary and necessary assets that you have, you'll be able to retain them, depending on the specifics of the state. You'll want to discuss that with the legal advisor that you're using in your bankruptcy so that you know the specifics in your case. But in general, you'll be able to retain the majority of those necessary assets. Now, I may have just raised more questions than I answered, and I hope this has been useful. But if you want to discuss this further, we'd be glad to visit with you. Feel free to give us a call. We hope this has been helpful, and we wish you the best.